Thank you very much for your kind introduction, Adam. First of all, I want to express my deepest gratitude to Professor Dotan-Todd for his kind invitation, and to Professor Adam Badasi for his thoughtful and careful arrangement for my participation in this conference. Okay, so today I want to briefly share with you my ideas about the validity of law, which is the very classical and long-standing issue in the field of jurisprudence. And I want to do so while carefully looking at the actual cases. Actually, the combination of the theoretical thinking and analytical thinking and the carefully looking at the actual problems and cases. This is the my long-lasting approach. So today's lecture's title is The Rule of Law, Legal Validity, and Constitutional Law. So let me begin. Okay. So let me begin with the current situation, which is very alarming. So this is the ratio of populist governments in all governments across the world. And you can see two parts. The bright color is left-wing populism. Thank you. And right color indicates right-wing populism. And you can see the rapid increase in the ratio of populist governments in the all governments across the world. And I call the recent situation populist cascades, post-populist cascades. And then what is populism? Well, I suppose some of you might be familiar with the definitional issues surrounding the populism. And then you might have heard of the ideational definition of populism, according to which populism essentially refers to the thing-centered ideology contrasting pure people with corrupt elites. On the other hand, another definition says that the populism is essentially the political strategy relying on direct support from unorganized followers. And cutting off the details, I have argued both of these definitions are insufficient and in one of my recent publications. And I tried to propose a new definition according to which populism is essentially the strategy, political strategy by which politicians or political parties assert themselves to be identical with or representative of pure people as opposed to the corrupt elites in the democratic process. So essentially, my own definition is a kind of combination of ideational definition and strategic definition, but at the same time, I add or I emphasize on the, some new aspect of the populist phenomena, which is the fact that this phenomena can be seen only in the democratic process. Okay, and then let me mention several features of this long-standing but recently developing the phenomena of populism. The first feature of populism is what I call anti-institutionalism. So it's whether or not it's right-wing or left-wing, populism has essentially tendency to go against the institutional arrangements, including the constitutional order. And so, yeah, so my today's talk is will be focusing on this feature. And other than that, I mentioned in my recent paper 4 features of populism, including the anti-inclusivism, for example, the exclusion of the LGBT people, or the racial or ethnic minorities in many, many societies, actually. Or the anti-internationalism, such as the Trumpism's the introduction of the tariff, or intergenerationalism can be exemplified by the backsliding of the climate change mitigation policies that can be seen in the North and South America. And also, populism show the anti-intellectualism. Okay. So then, what does it mean to democracy and the rule of law? Actually, we can see the democracy backsliding in recent years. So let me explain just a little bit this figure. You can see yellow line. Yellow line indicates the number of countries in democratization episodes. So then you can see a declining number for such countries. And then what is the blue line? Blue line indicates the number of countries in autocratization episodes. And then you can see rapid increase, right? And dotted line indicates democratic countries under autocratization, about which you can also see significant increase. And then what about the rule of law? Okay, the rule of law, which I suppose all people in this room are very familiar with, has been considered as the opposition to the rule of man. You can see, for example, you can see the many remarks about the rule of law or the somewhat similar ideas in classical writings, including the Aristotle, John Locke, or dicey. And then you can confirm that rule of law has been considered as the opposite to the rule of man. And then in the contemporary academia, we have two different and conflicting traditions about the idea of the rule of law, one of which is what we have called the thin conception of the rule of law, according to which only formal and procedural requirements are included among the all requirements of the rule of law. For example, Friedrich Hayek or Joseph Russ, or many others actually in the field of the legal philosophy have endorsed this conception. On the other hand, according to the thick conception of the rule of law, this idea implies not only formal and procedural requirements, but also substantive requirements. And such substantive requirements include, but not limited to, the democracy enhancement, or the respect for and protection of the individual rights, such as human rights. Okay. And then, what is the implication of populism to the rule of law idea? So populist leaders consider themselves as the leaders going beyond the law. So in this sense, populism challenges the both conceptions, thick conception and thin conception. Also, if you adopt the thick conception as opposed to thin conception, and then because you can see the anti-democratic trait in the populist movement and populist discourse and public policy, you can safely say that populism challenges the thick conception in a double way. Okay. And then let me share with you recent data according to which the rule of law index has indicated the fall in 78% of all countries surveyed from the year of 2016 to the year of 2023. So empirically, we can observe a fall of the rule of law, and such fall has been closely connected with the rise in populism. And let me add one small point. Rule of law index presupposes the thick conception. But if you take the thin conception as opposed to the thick conception, I believe you can see the fall of the rule of law across the world. Okay. And then let me briefly describe the current situation of the scholarship on the normative implications of the populism. Populism has been studied, much studied, in several decades, actually. And early works includes these books, and more recently, we can see many, many books, actually, and the countless papers published in the English-speaking world, French-speaking world. And actually, in Japan, in a small country in East Asia, we have many books and papers about the populism, actually. And what about the populist implications or impact on the idea of democracy? And you can see many books and papers as well. Then what about the rule of law or law in general? And then you can see a few anthologies about this important issue, but I want to emphasize this now. We can see research gap, by which I mean we can find a few studies by legal philosophers about the legal implication of populist movements and populist regimes. And then, based on my basic recognitions about the current status of the literature on the populist-related normative issues, I set up my lecture's aim like this. Well, the context of the problem is the validity of law, as I mentioned. And then let me share with you the whole picture of the current situations in the literature. As you can see, we have 4 different and primary views on the validity of law. The first is, of course, exclusive positivism, exemplified by the Joseph Ross, especially. But you can see some other very famous legal philosophers here, the first cell. And then the second position I want to mention now is inclusive positivism, exemplified by Herbert Hart and Jules Coleman and Kramer. And of course, we have the long and strong tradition of natural law, according to which the validity of law exclusively relies on the non-man-made law. And let me call non-man-made law morality. Of course, I think I'm aware with such interchangeability of the non-man-made law and morality, but to simplify and clarify the point of my argument in my talk, let me take such interchangeability of 2 words. And the 4th position is interpretivism, represented by Ronald Dworkin. Okay. And then my lecture's aim is to examine these 4 views on legal validity in the context of populist constitutional change. And more specifically, I want to ask one question. When a populist government undermines the basic principles of the Constitution through its constitutional amendment, which view on legal validity can address such a constitutional amendment in a plausible way? In other words, I want to examine each of the 4 views on the validity of law by putting them into the real world context, very serious real world context, which is the challenges, populist challenges to the rule of law. And my methodology is mixed. I adopt the thought experiment from Anscombe's the trolley problem to John Rawls' original position to Derek Parfit's of the scenario of the human extinction, for example. We can see many, many examples of thought experiment in the field of philosophy and political philosophy and legal philosophy. And in my talk, I follow such a tradition. On the other hand, I want to take real world examples of the populist constitutional amendment that can be seen in some other parts of the world than Europe. Why? Why I don't take any examples from the European continent? Well, one of the reasons for this is that I don't think that I'm not qualified to take any examples from the European countries. I suppose all of you are more knowledgeable than such cases, so this is one reason. At the same time, and I want to emphasize this point now, when we discuss the issues in general jurisprudence, I believe not only European cases, not only North American cases, but also the cases in other parts of the world matter as well. So we need to see not only the Western cases, but also the non-Western cases. So that's why in my talk, I pick up some cases from Latin America and Africa. Okay. And then let's see more closely actual cases of the populist constitutional amendment. And today, I want to focus only one type of such constitutional amendment, which is the removal or modification of presidential term limit. Okay? Let me share with you the background information about this. According to one of the recent papers, 1/3 of the presidents who came close to the end of their prescribed term attempted to remain in office between the year of 2000 and the year of 2019. And if you exclude established democracies from the countries you consider, and then you can see more than half of the incumbent presidents who have attempted to remain their seats, even though their term is closing the termination period. Okay, and 2/3 of such attempted remaining in their office have been constitutional amendments. So actually, if you look at the situation all over the world, and then the presidential term limits removal is very big issue, actually. That's why I pick up this type of the populist constitutional change today. And then what is the implication? What is the implication of such constitutional amendments? Well, I would say that such changes imply that the president can hold his or her position unlimitedly, and such president is someone like the ruler who goes above the law, beyond the law, and if we can say so, and then we can consider such a constitutional change as one deviation from the rule of law. And then let me share a short list of such constitutional changes. Okay? And all cases are taken from the Latin American countries as well as Africa. Here is my list. And then you can see 2 countries from Latin America, right? But more impressive is African cases. So please look at the right-hand side column. And then in Cameroon, the incumbent president has held his position since 1982. And the similar can be seen in Uganda. In other words, the removal of the presidential term limit has the huge impact on the country's political regime. More exactly, more specifically, such removal can create authoritarian government. And you remember my definition of populism. Populism occurs only in democratic processes. And then we can safely say that populism has a strong tendency to make democracy to undemocratic regime. And we can see real-world examples in some African countries. So that's my point, okay. And then let's move to the theoretical considerations while looking at such serious real-world examples. And let me begin with the examination of the exclusive positivism. The assumption here is that the validity of law relies on the separability thesis, according to which the morality and legality don't have necessary connection or link, and we can make a distinction between the strong interpretations and the weak interpretation of the separability thesis. One feature of exclusive positivism is the claim that we should take the strong interpretation of separability thesis as opposed to the weak interpretation. And then what is the possible and predictable argument made by the exclusive positivists about the populist constitutional amendment? Well, I speculate that they are like this. If the social fact of constitutional change in accordance with the legal procedure exists, and then any amendment is valid. Of course, they can add that the legal validity is one thing, and the moral judgment is another thing. And actually, this is a very important point, particularly in the Hartian argument. He famously emphasized the clear distinction between the legality or legal sphere and morality or the moral sphere. And when he does so, he emphasized that such a positivist picture of law and morality enables us to say that even if the existing law is valid, we don't have to refrain from the criticizing it, because morality is one thing and law is another thing. So in other words, the Hartian position is very liberal, not authoritarian at all. So, and his own soft positivist position doesn't exclude the possibility that the exclusive positivist take his point of argument. So that's why I want to emphasize this note here. And then let me show you my own thought experiment. Okay. So my own imaginable case, not imaginable, imaginary case is like this. Let me read the text. Since its independence from the former colonial power, the constitution of autocratia, imaginary country, okay, autocratia has had no limits of the president's term. Under this constitution, the current president has served over 3 decades. And you can see the real-world examples in line with such imagination. Okay. In contrast, Democratia's constitution had long included a presidential term limit provision, allowing any president to serve in 2 terms at maximum. However, the populist ruling party recently proposed the removal of that limit, supported in a national referendum. Then what would exclusive positivists say? Well, in the exclusive positivist view, the 2 constitutions are both legally valid, enabling the incumbent president in Democratia to serve as far as he is elected. And then my question is here. Is there no significant difference from the perspective of law as distinguished from the moral perspective? Is there any significant difference between the long-lasting lack and the new removal of presidential term limits? And if you think that there should be some difference between the 2 cases, and then you might not be able to rely on the exclusive positivist position, then let me move to the second view, which is inclusive positivism. The assumption here is that the conventionality thesis is the center of the validity of law. And then what would their argument be? I speculate that they would argue that if the master rule, which is the meta-level rule, such as the rule of recognition in Hartian theory, recognizes the constitutional amendment as legal, and then any amendment is valid. And then the question is, how can we identify such meta-level master rule? And as inclusive positivists, as well as exclusive positivists have urged, master rule can be identified through the observation of judges' convergent legal application, which is the essence of the separability thesis. Okay. And then we can add the same note as the exclusivist description. Okay. And then my thought experiment for inclusive positivist is like this. Let me read the whole text again. Immediately after the presidential term limit in Democratia's constitution was removed, several non-governmental organizations, which presumably work for the democratization of the country, for example, separately challenges the removal by lawsuits, arguing that the removal is unconstitutional and so null and void. However, no judges from lower to Supreme Courts didn't apply the NGO's claims, and they presumably concerned about the possible political backlash from the executive branch. And then what would exclusive positivists say in the inclusive positivists say? In the inclusive positivist account, the term limit removal is valid because this removal has been endorsed by judges today. Then my question is like this. Is it plausible to consider this removal valid when judges are incidentally accommodating to the executive and the legislative branches? Does everything rely on the actual attitudes of the judges? This is my question here. Okay. Then let's turn to the natural law. Their assumption is that legal validity depends on the non-man-made law, and as I mentioned, I assume the possibility of the interchangeability between the non-man-made law and morality. Although I'm aware this is a little bit controversial, but anyway. And then what would their argument be? They would argue that if a constitutional amendment violates morality, and then it's invalid. So their claim is essentially very simple, and to some people it's very, very forceful and convincing. But I dare to raise one question for the natural lawyers. Okay, so my third thought experiment is like this. Leaders of a populist incumbent party in Democratia have recently discussed how to change the constitutional clause that currently prohibits presidents from serving in more than 2 terms, okay? And then the leaders considered options are 2. The first option is to remove the term limit entirely, okay? Remove it entirely. And the second option is to loosen the current limits so that president can serve in 4 terms, not 2 terms, but they are not allowed to serve in the 5th term continuously. And then natural lawyers would obviously find first option invalid, but different natural lawyers might have conflicting views about the second option depending on their evaluation of the immorality of the second option. And I believe we have many, many theoretical and ethical issues here. And I sincerely welcome any comments and criticism after my lecture. But anyway, let me share with you my own question for the natural law. Well, I suppose that one can safely say that the option 1, entire removal of the presidential term limit, would violate morality more seriously than the option 2, okay? And the assumption here is that the moral assessment of the constitutional clauses to be a matter of degree. So this is the matter of degree from the 0 to countless. In contrast, the validity assessment of any legal clauses, including the constitutional clauses, is admittedly a binary judgment. So we say this legal rule is valid. That legal rule is invalid. And we cannot have any space between the valid legal rules and invalid legal rules. So then my question is, how can natural lawyers reconcile the 2 different ways of evaluation? In other words, I am trying to raise the theoretical and consistency-based argument rather than ethical argument here. Okay, and then up to now, we have seen, I hope, we have seen some problems with the possible prescriptions written by each of the 3 primary views on the validity of law. And then let's move to the last one, interpretivism, famously proposed by Ronald Dworkin. And the assumption made by Ronald Dworkin can be said to be that legal system is an institutionalized morality. So law is essentially one branch of morality in a broad sense. But at the same time, law is characterized by its institutions. So in a nutshell, we can say that legal system is an institutionalized morality. And then, what does it imply on the validity of law issue? Well, we can say that the legal provision's validity depends on its consistency with the past legal decisions. So, for example, Ronald Dworkin used the term of the institutional support. Institutional support. When one judge makes a legal decision, such judge needs to explore the world of legal materials, including the statutes and legal interpretations made by many other judges. At the same time, principle rather than the rule narrowly interpreted has a feature that it has moral trait. In other words, the validity of one particular law should be evaluated partly based on its morality. Okay. And then what would the interpretivist say about the validity of law in the context of the populist constitutional change? I speculate that the interpretivist argument goes like this. If a constitutional amendment deviates from the principles that can be drawn from the legal system's constitutional order consisting of the legal materials, including the constitutional clauses and the accumulative interpretations of each clause, then such an amendment can be said to be invalid. Okay, then how would interpretivist approach be able to avoid some problems I identified with its three levels, including exclusive positivism, inclusive positivism, and natural law. Now, let's see case one again. Interpretivists can find the removal of the presidential term limit in democratia invalid if it can be said to violate, the presidential term limit removal can be said to violate constitutional principles stemming from other constitutional clauses and relevant judicial decisions. By doing so, interpretivists can avoid the problem with the exclusive positivism, in my view. Okay. And then what about the case two implications, interpretivist implications on the case two? Well, it's possible for interpretivists to consider democratia's term limit removal invalid, even when judges to date have confirmed its validity. Why? Because interpretivism admits the possibility of judges' mistakes occurring in the real world setting. And actually, Ronald Dworkin mentioned this point in his Taking Rights seriously. Okay. And then what about case three? Interpretivists can admit the binary validity assessment because validity has two different aspects. The first is, as I said, the first is the consistency with the legal materials, consisting of the constitutional clauses, legal clauses, and interpretations about these clauses. And the second part is the morality. And as we already saw, morality judgment is essentially a matter of degree. So we can say this specific legal event is immoral to a smaller degree than that legal event or something like that. On the other hand, the issue is that validity judgment has the binary character. And then the question is how we can explain such binary character of the validity judgment. And in my view, interpretivist position can provide one explanation because in the interpretivist theory, validity judgment has consistency aspect, which sets up the threshold of valid. So if one legal event goes beyond the threshold, and then we can say such event is legal, it's legally valid. But if that event goes below the threshold, and then we should say that that event, legal decision by the judges or the legislative enactment or anything else should be invalid. So in these ways, I think that the interpretivism can avoid the different problems with its three rivals, okay? And of course, I'm very aware that my claim is very, very controversial, and any criticisms will be more than welcome, okay. And then let me conclude my talk. So what's the context I have focused on? That's the rise in populism. And then we already saw one significant literature gap. By literature gap, I mean the fact that the legal philosophers have paid little attention to the impact of populism on the rule of law as opposed to democracy ideals. And then, given such a current status of the scholarship on the populism-related studies, I set up my own lecture aims like this. My aim was to examine 4 primary views on the validity of law in the context of the populist constitutional change. And my methodology is a mixture of the theoretical part and the empirical part. I conducted the thought experiments. At the same time, the context has been drawn from the real-world examples of the presidential term limit removal, and I drew my cases from Latin America and Africa. And then, what are the major results? Let me begin my summary with the exclusive positivism. I argued that exclusive positivism cannot recognize a difference between the long-lasting lack of the presidential term limits and the new removal of such limits. And then I proceeded to argue that inclusive positivism cannot address the removal in cases of accommodating judges. And then, what about the natural law? Natural lawyers cannot distinguish between the matter of degree moral judgment and binary validity judgment. That was my argument. And then I suggested that the interpretivist position can avoid these 3 problems. In other words, the interpretivism can avoid the problem of the failure to recognize the difference between the lack and removal, and it can address the removal even in cases of the accommodating judges. And interpretivism also can distinguish between the matter of degree moral judgment and binary validity judgment. And if we, by the interpretivist views, interpretivist view in this specific context, and then I suggested that we should seriously take the idea of constitutional order in the context of the evaluating the validity of law. And then this is the last part of my talk. What is future agenda? What is future agenda? Well, in my talk, I focused on the presidential term limit removal, which is very, very specific issue. At the same time, I used the limited number of cases from Latin America and Africa. And then I want to leave the audience to think about the possibility of such examination by looking at the other forms of the populist constitutional changes, and by looking at the cases in other regions. Thank you very much.